Hey, welcome to the fun2000.com real estate podcast. We've got Oli here with us today, and we are going to talk about some 2025 updates to California law. Hi, Oli.
Hi,
Welcome. How are you?
good. How are you?
Doing well. So, there are a ton of legal updates. I don't know if you had a chance to look through that whole list that California Association of Realtors provided. We're going to focus today only on some interesting updates that involve both of on the non-judicial foreclosure side and the sales side. So if you're a real estate agent, you're going to be getting updated either through this podcast, through the Association of Realtors, or through your broker on laws that relate to foreclosures. And that's what we're going to talk about today. But did you see all the other updates to like evictions and landlord-tenant law?
I actually didn't I looked, but I didn't pay attention to every single one of them. There's a lot.
Yeah, well, the California legislature does not disappoint. Whether you agree with them or not, they continue to be very, very active. And today, for the sake of time, let's not get into whether we like these changes or not. Let's just talk about the mechanics and then keep it simple for today. How does that sound?
Perfect.
So, what did you understand? We now have two interesting laws that relate to real estate sales agents and how they can help their clients if they are facing foreclosure. What did you think?
So, from what I understand, if you're a seller and you're facing potential foreclosure, if you have a valid listing agreement with the broker who is licensed in California, you get additional 45 days to sell your property and for that reason not to face foreclosure.
In a nutshell, the new law allows borrowers who are potentially facing foreclosure, let's say they have fallen behind on on their payments, and they might not be selling quite yet. So they're not quite a seller, and that's why I wanted to, make this clarification. They might not be a seller quite yet, but they evaluate their options as it relates to foreclosure, and they like the idea of selling, or selling is their best option, or they have no other options. The borrower in that scenario in California now has the option to list their house on the MLS or whatever through an agent. They have to have a listing agreement and put it out there on the market in what is in the law says to be publicly available, or to be placed in a publicly available marketing platform is what it says.
Like
So,
MLS
right.
or Zillow.
And if you do that, and if you provide the listing agreement to the trustee, the foreclosing trustee who sends you the notice of default, then you get 45 days. So a 45-day postponement of your sale. So this doesn't really come into effect until there is a notice of sale. And so tell me, do you get
And
it so far? And what else do you want to throw in there?
yes, and I want to clarify 45 days postponement from sale, foreclosure sale, not a real estate sale. They get 45-day postponement from the foreclosure sale because
Right.
we're
Yeah.
talking about two different sales right now.
Right. We're talking about two different sales, but the sale that they're worried about that they want to postpone is the foreclosure sale. The other sale, they want to expedite that, right?
Correct.
So,
I had another question there because from what I was reading, there were two 45-day postponements. One is if you have listing agreement with a valid California licensed broker, and another one if you already have um contract, I guess, like a
right, right,
sale contract.
right.
Is
So
it
you
two
get
different things or is it one or the other?
no, it's two different postponements. So you can potentially postpone for a total of 90 days. So let's say during that 45-day postponement period, because you're listing the property, the trustee will be required, if you meet the requirements, we'll get into what those requirements are. The trustee will postpone the notice of sale for 45 days, postpone the sale for 45 days. So during that time, let's say you as the borrower and seller of this property that's facing foreclosure, let's say you find a buyer, then you can provide the purchase agreement to the trustee as well and get a new 45-day extension.
Okay.
So you see what you see what the purpose here is.
Yeah.
The
To
purpose,
let the borrower recover basically their not their money, like let the borrower to actually sell the property and pay what they owed.
well, that they will in either scenario, assuming there's equity in the property, the lender will get paid what they are owed, right? The borrower will pay what is owed. If there's not equity, then we're in a different kind of market, and this situation might not even happen. In 2008, 2009, that whole real estate crisis, we were in a no equity situation, and people were just walking from properties. Or they didn't care if they got a postponement. Those properties were in NOD status for years sometimes. So let's look at the requirements a little bit more closely. We do have on our webpage sold2000.com this summary, and you saw it. I wanted to be able to provide it to the public with a nice little title, but I think instead we will just have people contact us and we can forward them a link. You can email either Chuck or Oli at sold2000.com to get this legal updates summary.
When foreclosing on residential 1 to 4 property, this law requires an additional 45 days beyond the scheduled date of sale if the trustee receives a listing agreement from the trustor at least 5 business days before the scheduled date of sale. There is an additional postponement right based on obtaining an executed purchase agreement.
Okay, so that should clarify the question you were
Yeah,
answering before, right?
yeah, yeah.
So if the borrower sends us the trustor and the borrower, that's the same person. If they send the trustee, which we do, we run a trustee business. That's why it's important to us, but it's also important to our agents because we also employ agents. Um, they have the option to help their borrowers with this thing, but it's not going to be much of a help if the agent representing the borrower doesn't send the listing agreement before that, at least 5 business days
5 days,
before
yeah,
the
5.
scheduled date. So if it's 2 days before the scheduled date, too late. The trustee is not going to postpone.
Hmm.
So that's an important, very important requirement. This also prohibits the trustee from selling the property at the initial trustee's sale for less than 67% of the fair market value of the property. There's a paragraph that addresses it. Requirement of fair market value. With respect to residential real property containing no more than 4 dwelling units that is subject to the power of sale, meaning foreclosure,
Hmm.
containing a first lien or deed of trust. So this would not apply to a second. Let's say you got a HELOC or a second deed of trust, second loan. The trustee is prohibited from selling the property at the initial trustee's sale for less than 67% of the amount of the fair market value of the property. If the property remains unsold after the initial trustee's sale, it is required that the trustee postpone the sale for at least 7 days and authorizes the property to be sold thereafter to the highest bidder. The beneficiary or authorized agent shall provide to the trustee a fair market value of the property at least 10 days prior to the initially scheduled date of sale. This is there's a lot of things about this law that apparently the legislature did not think through, and I'm not sure if I'm just not understanding this properly, but I think this is just another one of those things that they didn't think through. Because if you have a first lien and that is a foreclosing first lien, and only $100,000 is owed, that notice of default and that notice of sale is only going to have $100,000 plus interest and costs of foreclosure. So,
But they want you to sell it for more, maybe so the borrower can recover this fund. So you basically you give the rest to the borrower. Is
well,
that the
at
idea?
see the way a trustee auction works is The opening bid cannot be any higher than the sum of the unpaid principal balance, in this hypothetical scenario, $100,000, interest on that. Let's add whatever interest is owed. Let's say it's another $10,000 that's owed in interest. Maybe
Mm-hmm.
they've missed 10, 12 payments, something like that, whatever the interest would turn out to be. And then the cost of foreclosure might only be another uh, $3,000 at that point. That's
Mm-hmm.
not going to get you to 67% of the amount of the fair market value of the property.
So now I'm wondering if this law is overriding the previous laws.
Well,
Because
that's interesting. I mean, maybe so. Maybe now the trustee under um, this new law has the authority to set the amount to a higher an amount
that's
that's much
60.
higher.
Yeah.
So yeah, it's unclear. It doesn't say anything about giving the overriding other laws, but maybe we need to do a little bit more research into that. Let's say that you're a borrower and you decide you want to list your property to get a 45-day postponement to be able to actually sell the property. There are some requirements. Here they are. Uh, for residential properties, 1 to 4 units, facing foreclosure, the sale shall not be conducted until the expiration of an additional 45 days if you comply with all the following requirements. The trustee receives the listing agreement 5 days prior to the scheduled date of sales. You can't wait till the last minute. Got to get that listing agreement to the trustee no more than 5 days in advance. Um, it has to be a legitimate listing agreement with a licensed real estate broker in California. And it has to become publicly available. It has to be placed in a publicly available marketing platform. So um, it has to be a broker. It can't just be some unlicensed person. You can't just put it on Craigslist, right?
Yeah. And so I'm assuming that trustees will be doing their due diligence and they will be looking at all of this publicly available websites like Zillow, like MLS.
Probably a little bit. Trustees do a little bit of due diligence and they do that for their client. A lot of times the client will be doing it as well. Um, the listing agreement should be sent by certified mail. Okay, certified mail, you know what that is.
Yep.
Postal service or other overnight mail courier service. Email doesn't count. So there are other notices that we can get, um, from prospective tenants and owner occupants, that kind of thing. Or the notice of intent to bid can be emailed to us. I think that was just a written notice, not this one. This has to be overnight or certified, something with tracking apparently, right?
Yeah, you cannot just
Oh, well,
put it in an envelope with a stamp.
right. So the next requirement says with tracking information that confirms the recipient's signature. So signature is required
Okay. Signature required.
and date and time of receipt and delivery. This postponement may be used only at one time.
Mhm.
Okay. So why don't you read to us the 45-day postponement based on the purchase agreement?
Kind of very similar. So the trustee receives 5 business days before the scheduled date of sale. That's similar.
Right. So that's the postponed scheduled date of sale. So now the
Mhm.
second time, once again, the 5-day requirement, right?
Yep. A copy of a purchase agreement for sale of property. So it's a purchase agreement that's already somebody is making a decision that they're buying it.
Right.
Purchase agreement must be bona fide and fully executed. So it should be signatures, it should be a legal, it's contract,
Hmm.
basically. Must include name of buyer, sales price, closing date, and acceptance by the designated escrow agent. Purchase price must be equal to or greater than the amount of the unpaid balance of all obligations of record secured by the property. sent by certified mail with USPS or another or other overnight mail courier service, with tracking information that confirms the recipient's signature and date and time of receipt and delivery. And this postponement may be used only one time.
From the trustee perspective, we're looking at those requirements in a way where we can represent where our beneficiary clients, properly and um, comply with the law. From a real estate sales agent perspective, we're looking at ways we can help our clients, right? So in situations where our agents would like to help those borrowers who are facing foreclosure and they decide that they want to sell, then here we have some additional tools. That's something that we know about, that and ways that we can help them um, if they're facing foreclosure, to not have that uncertainty and that question, will they be able to sell in time prior to foreclosure? So that was a question that always came up in the financial crisis and the real estate downturn from 2008, 2009. There were a lot of people out there that wanted to try to pay their debt. They wanted to try to sell the property, and um, they were even okay doing a short sale, but they didn't because they just thought, well, the bank's going to foreclose anyways. There's not enough time. They've already sent the notice of default. Well, the notice of default, how long does it last for?
Indefinite.
Yeah. A notice of default is indefinite. Um, so even if you've got received a notice of default, you don't really know exactly when the foreclosing entity, the bank or whoever it is going to publish and record a notice of sale. Once they publish and record a notice of sale, then you only have until the sale date. But now we have some postponement options, right?
Mhm.
Well, it's interesting also, though, you always had postponement options, but you just had to negotiate those.
Yeah, and people don't know how to deal with that too. And
Yeah.
especially in the time of crisis, still you have to convince people, you know? So even when there is an opportunity for you not to get a foreclosure on your record, you people don't understand all of the details and what their options are. So it's like you have to educate them.
Right. And that is helpful information. The the borrowers that are facing foreclosure, they have the hardest time. They're facing a lot of darkness and lack of transparency. They don't understand the process. It is transparent. It's a very transparent process, but if you don't go and research the process, then it seems very opaque and dark to you. So these are people facing a very hard time. And whereas before they were not willing to talk to us as brokers, or they were less willing to talk to us as brokers, I should say, because we did have lots of short sales during that time. A huge percentage of them were not willing to talk to us because they were just unwilling. They didn't want to face the difficulty that talking to their lender presented. They didn't want to look at the embarrassing situation that foreclosure is, and they had already decided in their mind that where they're going to go next, and they abandoned the property.
But how do you educate people in the most horrible time of their life, basically, when they're losing the properties, when they don't want to face it, they don't want to talk to anyone, basically. You come in, how do you convince them that that's what they need to do?
Well, this law, I think, opens that up a little bit. So, whereas before the brokers that were trying to get their business, that was us sometimes, um, they were the last person that the borrowers wanted to talk to. Now, hopefully, this new law helps them to have a meaningful discussion, at least with people that can actually help them. The law is authorizing us to help them. So it's something for us to remember that we have this on our side now to help people who are facing a crisis. And I wonder if the legislature is feeling like, well, this is a good time to pass this law because for a long time now we've been talking about a difficult real estate market ahead of us, but it just keeps going up and up and up, and the economy keeps getting hotter and hotter. And now there's talk about interest rates coming down. It's really hard to see what is going to happen, but what are your thoughts on that?
I think it might be a sign of whatever they know and they don't talk about, you know.
Well,
They
they don't
just
actually know. Nobody knows. It's a market thing, right?
yeah. Like right now we discussed only the real estate part of it. How can we help the borrowers, you know? And here we have also another side of our business. We are helping the lenders as well. Right now, they are getting kind of like postponed for
Yeah.
90 days.
So how do we help our lenders? Well, I think we at TD Processing Service, we're always good with this as we get into the details. We make the right decision for our clients. We look closely at the documents. We don't wait for an attorney to review stuff. This is non-judicial foreclosure, and the trustee is given the discretion to make decisions that they are authorized to make. So this, to answer your question, how do we protect lenders best in with these new scenarios? Well, first, we look at we get to know the law, right? And that's what we're doing right now is showing or working on, making sure that we've discussed this, let everybody know what the law is, that we and understand it ourselves. We can reject postponements if the requirements are not met. That's what we do.
Hmm.
First, we understand what are the grounds for rejecting a postponement request. And I can see various grounds here. We get a, a a listing within the 5 days. It's too late. We're going to reject it. You didn't send it via certified mail with tracking to our office, right? There was no signature requirement. It was just dropped off. Who knows when we got it, right?
Hmm.
Um, the the listing is not actually being marketed, right? Maybe we don't want to make that call ourselves. I don't know. That one's kind of tricky because what if agents have pocket listings? Well, that's a pocket listing. That was something we discussed with the Ryan firm, and maybe we want to give a little shout out to the Ryan firm because they're a great law firm that specializes in non-judicial foreclosure and foreclosures, and they took the time to specifically Andrew took the time to teach us about this law. We have our CAR update, but we also have the updates that we get on the TD processing non-judicial foreclosure side from law firms like the Ryan firm, and you can look them up. We refer clients to them. We've referred multiple clients to them over the years, and these are the kind of attorneys that you want to deal with in a situation like this to help with this exact same question that you're asking, which is how do we help our beneficiary clients? Well, one is, get them in contact with good attorneys if they have a legal question, right?
Hmm. There was another question for me, like we've seen multiple files where the borrower would be doing whatever is possible, not necessarily to resolve the issue, but keep postponing.
Mhm.
So that's, I think, something that we will have to check and recognize. When is it a real sale? Like when do they really want to sell the property, or when it's just, we just jerk you around and
Mhm.
let you spend some more time.
What do borrowers typically do when they don't really want to sell, but they just want to delay and continue to try to give themselves time for this difficult process? That they have a weapon in their pocket. What is it?
Bankruptcy.
There is a protection in the bankruptcy code called the automatic stay provision.
Okay.
So there's an automatic stay. The moment you file a petition um, in bankruptcy, you it automatically get the protection of the bankruptcy laws that freeze any action against the borrower, and that includes foreclosures. So the moment they send us notice that there is a new bankruptcy petition, all they have to do is just tell us that, give us a case number, something like that. We can verify that, but it doesn't even have to be a legitimate petition. They can get in trouble for filing a bad petition, a fraudulent petition. Um, they can get in trouble, for abusing the bankruptcy laws. But they do get away with this. They do postpone foreclosure because of bankruptcy. And well, now they have an additional weapon in their arsenal.
90 days.
Listing agreements and purchase agreements, 45 days and 45 days. So yeah, we do help our clients by knowing what these requirements are, and um, we make decisions without waiting around for help. There are some things where we'll tell them you're going to have to get legal advice on that. We will have to make some decisions. We will have to get some decisions reviewed sometimes by counsel, but there are a lot of trustees out there that don't make any decisions on their own. They're always going to go ask an attorney because there's a legal question and they don't want any legal exposure. They don't understand that this is non-judicial foreclosure, and they do not understand the discretion that is given to a trustee to act reasonably on behalf of their beneficiary. So that's how we're different. We do understand that duty that we have. It's an important duty, and I think this is one way we will continue to set ourselves apart from other trustee services.
Agreed.
All right. Well, thanks for joining me, Oli.
Thank you.
And to everybody listening, thank you for joining us on the fund2000.com real estate podcast. If you have any questions about this, if you want to see our blog post about legal update 2025 regarding listing agreements and purchase agreements and foreclosure, email either Oli, O-L-I-E, at sold2000.com, or me at Chuck at sold2000.com, and we'll send you a link. And if you have any questions, let us know. Thanks for listening.